All right, well, thank you everyone for joining us today. As you most likely know, this is the Commercial Lease Negotiation Tactics for Small Business Owners presentation. My name is Jake Christensen. I'm an associate at Aaron Fox, which is a law firm that has multiple locations, but I work out of our San Francisco office. Before we get started, I just want to let everyone know that this workshop is part of a collaboration and partnership between the City of Oakland and the Lawyers Committee for Civil Rights. So very glad to be working with them to put these on for the last couple months. And because of this partnership, the presentation itself is focused on Oakland, but we also can provide information on San Francisco and San Jose. So to the extent that we have folks from SF or from San Jose here for the presentation, you can go ahead and just comment in the chat box and we'll make a note of it so that we can cover those locations. If we only have folks from Oakland or other areas outside of San Francisco and San Jose, we'll just cover Oakland and then move on to the negotiation portion of the presentation. And the main part of this presentation is really just to provide information. It's not to be taken as legal advice. If you're looking for legal advice on a no-cost basis, the Lawyers Committee is actually offering commercial lease consultations. They're 1 hour, no cost to you, and they are staffed by volunteer attorneys like myself. So if you're just looking to talk to a lawyer, get an idea of what your rights are under your lease, get some advice on negotiating with your landlord, this is a way to save some money while things are tight and get some actual legal advice to help you figure out your next steps. And we'll talk about how you can sign up for those toward the end of the presentation. So our agenda for today is going to be divided into 3 parts. First, we're going to talk about the initial steps you want to take before you start the negotiation process with your landlord. We'll move on to relevant protections within the 3 primary Bay Area cities. And then we'll finish with tips for negotiating with your landlord. And we will stop for questions after each segment, but if you have questions as we go along, you can pose those in the chat box and then Anna will interrupt me and I can answer them. And we'll also stop after each segment just to make sure that we cover anything that came up during that preceding part of the presentation. So when you are getting ready to negotiate with your landlord, the first thing you're going to want to do is locate a copy of your lease. And when I say lease, I mean every part of it. Oftentimes there's a primary lease document. There may be an addendum, an appendix, exhibits to the lease. Oftentimes these are form documents that are just filled in with your information. And so there may be specific requirements or language that's added through an appended document. So you just want to make sure you have the whole universe of the agreement between you and your landlord. If you sublet your space from someone, that means that you have a sublease with that person who was the original tenant of the space, and then they have a lease that's known as the master lease with the owner or landlord of the space. And so you want to make sure you review both of those because there may be some rights in that master lease that apply to you as the subtenant that maybe were not included in your sublease. So it's just important to have the full universe of documents that apply to your situation. Also, if you've leased your space for multiple terms, say you've been there for years, maybe decades, you want to pull every prior lease if you entered into a new one upon renewal, or all of the extension documents. A lot of times the original lease will just include an option to extend. You can exercise it with a simple letter saying that you want to do that, or you fill out a short extension document included with the lease. So just gather all of that and keep it in one place. If you don't have a lease, this is a really good reason to sign up for one of our commercial lease consultations. It's going to really depend on your agreement with your landlord through prior negotiations orally. And so it'll just be important for you to speak with one of our volunteer lawyers just to get a sense of what you agreed to, what your obligations are, and not having a written lease can oftentimes give you possible options to terminate early if that's something that you're needing to do. So as you review the written lease, there are some different terminologies and different paragraphs that you want to look out for. And we don't expect you to fully understand them. Oftentimes, we as lawyers who don't practice in the real estate space on a regular basis, it does take a little while just to figure out what the key provisions are. But you can look out for these buzzwords and maybe flag them with a sticky note or highlight them. It can just be helpful when you come to your negotiation or your consultation, to have identified those provisions. So the first of these is going to be a common area or other shared expense provided in the lease. These are sometimes referred to as CAM, C-A-M fees, common area maintenance fees. And these are usually under a paragraph that is denoted additional rent. So there may, in addition to your monthly rent, be additional expenses like property taxes, utilities, janitorial services, different things that are required to be paid by you in addition to your rent. So you just want to get a sense of what your full obligation is. You'll also want to look out for the word abatement. And this is a term that it means that your rent is reduced and depends on the period, but there may be provisions in the lease that allow you to abate your rent on the occurrence of certain events. And that could be destruction from an earthquake or fire. I've seen it in leases where the tenant is not able to use their lease space for any purpose. It allows abatement and non-payment of rent. So you just want to look for specific provisions that could be helpful to you there. There could be other abatement options if you aren't able to access your building, which a lot of folks haven't been able to because of the shutdown or the lockdowns, or if your landlord's cutting off services. We've run into that where tenants are still paying their rent, but they're not occupying the space because they're working from home, but the landlord is shutting off utilities and doing renovation work on the space. While they're still paying rent, they're still in possession of the premises. And so it's just good to see if there are any bases for you to be able to potentially get a reduction in your rent or refuse to pay rent. If you see the words force majeure anywhere in your lease, make a note of that. Force majeure clauses essentially mean acts of God, and they are enumerated events that would excuse you from obligations under the lease, including paying rent, possibly termination, depending on how friendly it's drafted. But if you see those words, there could be some support for reduction or forgiveness of rent. And if you see anything that guarantees your right to access or use the premises, this is a particularly helpful provision if one exists in your lease, because if you can't access it because the landlord is preventing you from doing that, or if you're not able to use it as required or intended under the lease, then that could be part of your rights as a tenant that would lean in favor of a reduction or forgiveness of rent. If you see condemnation or casualty provisions, these are pretty common in California leases, and particularly in San Francisco, given our history of earthquakes. And for that reason, these are often drafted usually in two parts, where if there's less than 50% damage to the premises and the landlord can fix it within a certain amount of time, then you have to continue to pay rent or maybe at a reduced rate. And if the landlord doesn't complete the repairs within that amount of time, or if the property is damaged more than 50%, it gives you the option to terminate. Now, that language specifically wouldn't apply to the pandemic situation that we're all in, but if it covers loss of access or use due to governmental action, which I have seen, that could be a basis for you to cite to possibly terminate your lease or to not have to pay rent during the lockdown periods. If you are in a building with multiple commercial spaces, like a food court or shopping mall, something along those lines, there might be a clause in your lease that requires the landlord to meet certain obligations, such as having a certain level of occupancy or a certain percentage of stores in operation for a certain number of hours a day, a certain number of days a week. So anything like that could be grounds for termination or other rent reduction. Also keep an eye out for the words quiet enjoyment. This essentially means that when the landlord turns over possession to you, that you have the right to quiet enjoyment of the leased space. If the landlord's interfering with that at all, could be additional grounds for you to cite for rent reduction or forgiveness. We'll talk about this a little bit later, but for security deposits, if there's a provision that requires you to repay it, there's usually language where the landlord can apply the security deposit to miss rent. And if the landlord draws on the security deposit, you have a certain amount of time to repay it. Not all leases have that language, but it would be good to know if yours does. And in terms of other options outside of the ones that would maybe be explicitly stated in your lease, really good idea to talk to one of our commercial lease negotiation volunteers. So if you can sign up for a consult, they can maybe talk about some of those options. And commercial frustration of purpose would be one of those. It just means you cannot satisfy the purpose of the lease. Usually it says that it can only be used for operation of hair salon or whatever your business is. And so there could be an argument under commercial frustration of purpose that you were not able to meet what the stated purpose under the lease was. So once you've reviewed your documents, you've kind of looked out for these keywords, you're going to want to reach out to your landlord if you haven't already. And it's really important to keep an open dialogue with him or her throughout this process, even if you're not paying rent, just so that they know what's going on. And so at the bare minimum, you're meeting your minimum requirements for the local eviction moratorium in your location. So even if the landlord isn't responding, you have proof that you have sent an email to the landlord, you sent a hard copy letter just saying that you're financially impacted because of COVID and that you're not able to pay rent as a result. And we'll talk about how you meet those requirements here in a second. As you're going through this process, gathering your lease documents, exhibits, appendices, renewals, all this, as well as corresponding with your landlord, you want to keep copies of everything. If you have an original of your lease, I would make a copy of that and then keep the original somewhere safe. Create an email folder in your email account where you can drag and drop all sent and received correspondence with your landlord. You can scan in your lease and other documents as well and keep electronic copies there. For screen shots of text messages, you can't save an individual text the same way you can an email, but you can take a screenshot, email it to yourself, keep that in that folder. And voicemails, even though they're just a voice file, an audio file, you can also save those to the voicemails app on an iPhone, or you could email the message to yourself. You want to keep a record of all correspondence, of all the underlying documents, and have them in one place where it's easy to find them. It's just going to make it easier down the road if the landlord does try to evict you, or if you get into a dispute about repayment and all those sorts of things. And at this point, we'll pause to take any questions that anyone has so far.
I'm not seeing any questions, Jake.
Okay. And as I mentioned before, we're going to start with Oakland in terms of the commercial eviction moratoria. But if we have any folks from San Francisco or from San Jose in the chat, please just write San Francisco, write San Jose. We'll be sure to cover those. If we don't hear from you, then we'll just go ahead and move on to the negotiation portion after we cover Oakland. All right, so Oakland's commercial eviction moratorium currently extends through March 31st of next year. Oakland originally had its own moratorium that was passed by the city council earlier in the year, and it was later tied to the statewide orders. The most recent one issued by Governor Newsom, an executive order at the end of September, allowed cities to extend eviction protections through the end of March. And so Oakland immediately extended its protections to the absolute latest date under the order. This obviously gives a lot more peace of mind to those business owners who are operating in Oakland, you're not having to go month by month, which was the case in San Francisco for a while, or every 2 months, which is sort of where San Jose and San Francisco are at now. And so what this means is that you can't be evicted as long as you are not able to pay rent because of the financial impacts of COVID, as long as you meet these requirements. So you have to be a commercial or other small business tenant with 100 employees or fewer. And if you're a nonprofit organization, regardless of your size, you also qualify. And those businesses that meet these requirements can't be evicted for non-payment of rent. And the basis for the non-payment is attributable to a substantial decrease in income. Now, we've had questions about what a substantial decrease in income means. The moratorium does not define it, and so it really is within your judgment. You know your business, you know what your numbers are normally at from previous years, and substantial decrease means not able to pay your rent, not able to pay all of your bills, and still make a living. They don't really. There's no rubric, and it's flexible by design. So if you feel that you've been financially impacted, you've experienced a substantial decrease in income, then you qualify. So this protection is going to be a defense to any attempt by your landlord to try to evict you for non-payment of rent due to COVID-19. Now, it's important to note that this only protects you for non-payment of rent. So if there's a nuisance issue, other obligations under your lease that you've not met besides the requirement to pay rent, those could be bases for the landlord to try to evict you, but cannot evict you for not paying rent because of COVID. So it's important to keep in mind that while you do not have to pay rent during this period through the end of March, on April 1st, the rent would technically be due. So it's really important to start working on negotiating with your landlord now, either to obtain a reduction in rent so that you can start paying and be current on rent, and then also to negotiate a deal to repay the back rent or have it forgiven. And that's what we'll focus on in the next segment. But it's really good to have those agreements in place sooner rather than later, because it's going to be really hard to negotiate at the end of March, beginning of April, once the rent is due and the protection no longer exists, unless it is extended, which it very well could be. So keep an eye out for that. The good news is you're covered at least at the end of March. Folks are starting to get vaccinated. Things are going to hopefully start to pick back up, reopen, and that should hopefully get us closer to that, and they'll reassess and see if they need to extend the protections. All right, I didn't see anybody drop in the chat box, and so going once, going twice for San Francisco or San Jose. Okay, we will go ahead and go right up.
Jake?
Oh, yep.
There might be somebody from San Francisco. I see somebody raising their hand. I'm going to allow her to talk.
Oh, say that again. The last part.
I'm going to allow her to say something. She might have just raised her hand for.
Okay, well, we'll go ahead and quickly go through San Francisco and San Jose. It won't take that long, and that way we're covered. All right, so San Francisco, its protections currently extend through the end of January, so a few months less than Oakland. Prior to the governor's order at the end of September, San Francisco was extending its moratorium every month, and so it was usually at the end of the month, so you had to sort of wait with bated breath, sort of assuming they would extend it, but waiting for them to confirm it until the last couple days of the month. And fortunately, they've now extended it at the end of last month until the end of January. And so San Francisco's protections cover any rent missed from March 17th, 2020 until January 31, 2021 for the following types of businesses. So you have to be financially impacted by COVID-19, and any kind of financial impact, there's no, again, standard here similar to Oakland. So if you've seen a reduction in your receivables, then that's clearly a qualifying factor. You have to be registered to do business in the city and county of San Francisco, and your gross receipts have to be at or below 25 million for 2019. So if you meet those requirements, and you are a commercial tenant, a subtenant, a month-to-month, or a holdover tenant, you're going to be eligible for that protection. And keep in mind that the non-payment of rent, the rent in that includes monthly rent, the additional rent, which we talked about a little bit earlier, the common area maintenance fees, and similar additional costs, as well as repayment of security deposits, late fees, and interest. So all of that is included in the moratorium. To claim protection under San Francisco's eviction moratorium, you want to provide written communication to your landlord. This does not have to be a formal letter, it doesn't have to be from a lawyer. You don't have to provide any financial proof. A lot of landlords are trying to ask to review your financials, to show accountings or different bank statements, sort of what's coming in, what's going out. You're not obligated to do that. So don't feel pressured by the landlord. All you have to do is say that you are economically impacted by the pandemic and you're not able to pay rent as a result. It could technically be in the form of a text message, which is a little bit harder to document. You have to screenshot it and save it. So an email will suffice, a written letter where you sign it, make a copy and provide the original. That also works. Ideally, in that situation, you would want to send the letter return receipts requested so that you can confirm that the landlord received it and signed for it. And so in that case, and you could also in an email request a read receipt, which would send you an email after you send your notice that the landlord's opened it and read it. And you want to continue to discuss payment terms with your landlord monthly. And that doesn't mean you have to pay something monthly. It just means you have to say, hey, I'm still impacted. I can't pay anything right now, or I can't pay my full rent, but I can pay 50% or X amount. Just keep those dialogues going. And again, make sure you document everything. So do that every month. And it's important to note that you're not required to pay any rent during this time. We have some landlords that are saying that individuals have to pay their rent, regardless of the moratorium, threatened eviction, those kinds of things. And so your rights are to not pay any rent if you're economically impacted. But of course, you're encouraged to pay what you can because that is ultimately going to reduce the amount that you have to repay down the road. And while San Francisco's protections extend to the end of January, your landlord can agree to additional ones in his or her discretion. So this is where that negotiation component really comes through, and how it's important to try to negotiate something that's going to work for you that's not necessarily tied to this moratorium deadline. And it's important to note that these moratoria are not rent relief. So you still owe the rent that you're not able to pay. It just gives you a defense to eviction for non-payment of rent. And so it's really important to work out some sort of agreement so that you are not caught blindsided with a large amount of back rent due once the moratoria expire. It's also important to note that this moratorium for San Francisco prohibits your landlord from modifying your existing lease. So if the landlord is trying to add new terms or new requirements, the landlord technically can't do that. And so could be a good reason to sign up for one of the consultations just to get a sense of what the landlord's trying to do and to see whether that is actually permitted under the existing lease as it existed on March 17th. So your landlord cannot evict you without providing a written notice. And if that written notice says that you are being evicted for non-payment of rent, the landlord has to give you an opportunity to pay back that missed rent. And it has to be at least a 30-day period. And so after the 30-day period, if you are still not able to pay, but you're working with your landlord, then you're going to continue to qualify for the defense from eviction under the moratorium. So in terms of keeping the open dialogue, open communication, this is why it's important to keep working with the landlord, come up with some sort of payment plan, even if you say that you'll start paying once you're able to reopen after the lockdown ends. those sorts of things. Any kind of agreement you can reach that's going to be workable and achievable for you, it's good to get that in place sooner rather than later. But keep in mind that if you have not paid all outstanding rent, either after the agreed repayment period ends or after the moratorium expires, whichever is later, then your landlord could pursue eviction for non-payment of rent. We're unsure at this point how courts are going to handle these cases because the moratoria have been in effect for months, and so the housing courts have not been able to hear non-payment of rent cases for these covered businesses. And oftentimes in landlord-tenant court, they will send the parties to mediation and try to resolve the situation, come up with a payment plan so that the tenant can stay in the space. Hopefully that will continue. And so just keep in mind that even if an eviction action is filed against you after the repayment period or moratorium ends, that it's not the be all end all. There's still a chance to work it out and keep your business going. So San Francisco, much like the rest of the state, has slid backwards in its reopening phase with the increases in cases. And so I'm sure many of you have been similarly affected with the elimination of indoor dining and outdoor dining, reduction in capacities and businesses. And so we're waiting for this latest wave to decrease and then hopefully resume reopening and go back to where we were in October and November. In terms of resources specific to San Francisco, there have been some aid programs that have reopened. If you just Google SFOEWD, there is a page with COVID-19 resources for business owners and for landlords. Some of the different programs that have reopened include the SF Shines program, which is listed here. There's also talk of relief at the federal level, but these smaller grants, Shines is a $5,000 one-time grant, which means you don't have to repay it, which can help cover different things. There's also the SF Help loans, which are zero interest that you still have to repay, but at least you're not paying anything extra to get the money to get by, and it can be used for any of these listed expenses. There is also the Economic Injury Disaster Loan program, EIDL, through the Small Business Administration. These are low interest loans with a very long repayment term, similar to a mortgage. And so this could give you some options, and usually up to $2 million of eligibility to help bridge the gap between now and when things can reopen. And we'll go ahead and move on to San Jose. So San Jose was being a little more cautious, much like San Francisco, with extending its protections. However, at the end of last month, it did extend its eviction moratorium for commercial businesses until the end of March, just like Oakland. And so for now, San Jose and Oakland both have that March 31 end date to keep in mind. San Jose's moratorium is structured a little bit differently than the other two cities. The way that it works is that commercial tenants have 6 months after the moratorium ends to repay the first half of any back rent that's owed. So say you paid partial rent during the shutdowns and while the moratorium was in place, what you did not pay during that period, whatever was not forgiven or reduced, would be placed into a pot essentially, and you would divide that in half, and you'd have 6 months to repay the first half, or by September 30th if the moratorium isn't extended. And then you have another 6 months to repay the balance, the other 50%. So basically give you a year to pay back what you owe. During the period that you weren't able to pay, the landlord can't charge you any late fees or penalties or interest, even if they're provided under your lease. So that can be a really easy way to exacerbate the already large amount of rent that you owe. And the good news for San Jose folks is that there can be no charges or additions added on top of that, which ultimately will just help you get it repaid a little quicker. And the landlord also cannot ask you to waive your rights under the moratorium. So San Jose's moratorium in particular is pretty strict as to landlords, really makes it explicit that landlords can't engage in bad behavior, try to get you to not exercise your right under the moratorium. And so before trying to evict you for non-payment of rent, your landlord has to provide a written notice saying why you're being evicted. And if that says it's for non-payment of rent, you are going to be protected. The notice also has to include a multiple page notice of tenants' rights. And this just explains what your rights are under current protections under existing state law. And the landlord also has to provide you with specific resources for rental assistance. And so San Jose's protections are really geared toward helping you stay in the space, helping you continue to work with your landlord, find ways to pay the rent that you owe. And it's really well done out of the three. So along with the requirements when serving you with your eviction notice, the landlord also has to comply with the moratorium. So we have a lot of landlords that are trying to get you to not exercise your rights, which is against the requirements of the moratorium in San Jose, and technically is just not allowed in San Francisco or Oakland. But in San Jose, its moratorium has some teeth in that the landlord could face fines or penalties, including damages to you or injunctive relief, which would mean a court would order the landlord to stop bad acts, whether it be threats or pressuring you to continue to pay rent even though you are not financially able and qualified under the moratorium. And this is going to apply when the landlord tries to retaliate or tries to deny you rights or protections under this ordinance as a small business tenant. So any retaliation, any denial or attempt to deny you of your rights is going to be possible grounds for penalties or punishment of the landlord. And we'll take a break. Any questions about Oakland, San Francisco, or San Jose?
I don't see any questions. Oh, wait. Give me a second. Jose, you're allowed to talk. Please. I can't hear you, Jose. Maybe we can try in the chat box.
Yeah, Jose, if you want to pose your question in the chat box, we can address that for the end of the presentation. And if folks have more questions that come up as we move on, we can just take some time for Q&A at the end of the presentation. All right, so we'll go ahead and move on to the third part of the presentation, how to negotiate with your landlord. So the first thing that I tell tenants when I meet with them that they need to remember is that even if you don't feel like it, you do have the upper hand in this situation, and we're going to talk about why here in a little bit. But the first step, is how you get your landlord to come to the table and negotiate. And to do that, it's really going to be helpful to put yourself in your landlord's shoes and think about his or her perspective, what his or her goals are, and how you can harmonize those goals with your goals of trying to keep your business going and to get some sort of forgiveness or reduction in your rent. So in approaching that process, you want to make sure that you make a realistic ask. And the reason is you don't want to commit yourself to something that you are not feasibly going to be able to achieve. You don't want to say, my business is bringing in less than 50% of expected revenue for this month, but I'll be able to pay full rent for the month, and I'll be able to pay 50% of monthly rent toward the back rent that I wasn't able to pay during the shutdown periods. Locking yourself into set amounts when you don't know how much money is going to come in, you don't know what things are going to change with the state of the outbreak, whether businesses are going to be shut down completely versus just having their capacities reduced. So we have some tips on how you can sort of make this a little more flexible, but you want to take a realistic look at your situation and come up with a real ask that is going to be your best possible scenario, because you and your landlord are going to kind of start on your opposite sides and then try to work toward the middle to find something that's going to work for both of you. So don't be afraid to ask for the best possible scenario. And this is really going to avoid repeated renegotiations. If you overcommit and aren't able to meet it, you're going to consistently fail to meet what you said you would do under these negotiations. It's going to annoy your landlord. It's going to be harder and harder to renegotiate every time. So to the extent you can negotiate once, get to a reasonable agreement that'll get you through until things start to reopen and more folks are vaccinated, it's just going to make things better in the long run, and it's going to keep you on your landlord's good side. And so in doing this, again, don't be afraid to ask for the moon. And that could include, abatement of rent for the rest of the pandemic. We don't know, how long the pandemic is going to continue to rage while folks are starting to be vaccinated. And so having it be tied to something indefinite, would benefit you in the long run. So again, you're not having to renegotiate. So maybe you have your rent reduced by 50% until the pandemic is, declared over. Or into a lower stage. It could be in the form of requesting extended deferrals beyond the moratoria expirations of the end of January for San Francisco or the end of March for San Jose and for Oakland. Maybe you ask, until the end of 2021 or the end of your lease, spread out the payments that way just to give you more time. And that could be deferral of payment of back rent, or it could be stretching out the rent reductions and getting more time for you to repay rent is also going to be important as well. Some options that other folks have successfully pursued with their landlord or on their own, you could reach out to a bank about converting the rent into a loan that's payable over a fixed term. Some folks have used their EIDL loans for this because there is an extended repayment term and low interest, and that would allow you to extinguish any unpaid rent and then focus on reaching a deal for your rent moving forward. So maybe you get your rent reduced by 50% from whichever month, either retroactively or moving forward. And then you would be able to repay the back rent by getting some sort of long-term loan. You could ask your landlord if you put down a deposit, especially if it's a larger one. Some landlords require 2 months or more, or some require first and last month's rent in the deposit. So you could say that last month's rent and the deposit are sitting there. See if the landlord will credit those amounts toward your back rent to help reduce what you owe and then give you more time to repay it. I mentioned earlier that sometimes your leases will require you to repay the deposit or last month's rent if it's drawn on by the landlord because you didn't pay rent. And usually you have a set amount of time to pay it back. See if the landlord will give you more time. And also see if the landlord is willing to forgive rent that's been unpaid. Especially if your landlord owns the building, maybe inherited it, or at least owns it outright. Might be a little bit easier for him or her to do that versus a landlord that has a mortgage on the property and has bills related to the building to pay as well. And you could possibly motivate the landlord to forgiveness of back rent if you promise to pay full rent moving forward. The landlord might say no, but you don't know if he or she would say yes if you don't ask. If you are in a fortunate situation and your lease term is about to end and you can walk away from your lease, you could consider leveraging an extension of the lease if you're okay with the space and planning to continue your business. Just because the number of vacancies in commercial properties in the Bay Area only continues to increase. More businesses are deciding to close permanently or indefinitely and just relocate out of their leased spaces. And so it's really in your landlord's interest to keep you in your space versus having to possibly renovate it and get it ready for another tenant. If you've been in your space a while and new city code requirements have been implemented, the cities love to use the tenant turnover period to force those new requirements on landlords. So, it could require building out of a bathroom to make it ADA compliant. It could involve installation of new smoke hoods and different things if you're a restaurant. It really depends on the city, but it's only going to cost the landlord more money to try to evict you if you're not currently on rent at the end of your lease, and also pay a broker to try to find someone to take over the space, and they're probably going to have to lease it for a much lower rent just because of the glut of commercial space that's available. So all of those things are really in support of the landlord trying to keep you and make an offer that's going to be beneficial to you as well as the landlord. You can also ask the landlord if he or she's receiving any mortgage assistance. The big banks like Bank of America, Wells Fargo, they are offering mortgage assistance, deferral of payments or forbearance of payments for the mortgagors. And so if your landlord is getting any kind of assistance and is willing to admit it, that if they're getting help, then they should be willing to give you a break because, they don't have the bank breathing down their neck like they might be to you. So it can just help to kind of level with them and see what they're willing to disclose. But just because they're receiving assistance doesn't mean they have to extend that to you either. Just keep that in mind. And we've talked about this a little bit ago, but along with coming up with a realistic ask is that you don't want to overcommit. And so possibly propose tying your repayment to a percentage of your monthly revenue. So say, 5% of what I bring in, through the end of the lease or through the end of 2022 is going to go toward my unpaid rent. And, by December 2022, if it's not paid off, then, the bulk of what's left will be payable then. You then would have to repay that, or you could possibly renegotiate additional repayment terms with your landlord. You could also ask to convert your base rent to percentage rent. The benefit of both of these is that you're not tied to a set amount. And so not knowing what you're going to bring in, this is just going to be a percentage, 15, 25, 30% of what you bring in versus, $5,000 and you only bring in $4,000. And I think a way to pitch this to a landlord is, of course, it's not a set amount. You don't know what it's going to be because I don't know what my income is going to be for the month. But when things start to pick back up and the business is doing well again, you could potentially make more from percentage rent than you did before the pandemic at the flat base rent. So while the landlord would probably bring in a little bit less than the standard set rent rate initially, it could potentially bring more to the landlord in the long run. And worst case scenario, even if you only make $1, the landlord is getting a part of that. So it's some money versus no money if it's an unreasonable monthly rent that you can't afford to pay. And while you're going through all of this, this process, gathering your documents, trying to talk to your landlord and maintain open communications, don't compromise your sanity in the process. If your landlord is threatening you, being verbally abusive, just not being reasonable, you just need to do the bare minimum under the moratorium in your location. Make sure you're at a bare minimum communicating in writing that you're struggling because of the pandemic and that you can't pay rent. Save the documentation and wait for the landlord to respond. But if they're not engaging in helpful dialogue, you've at least met your requirements, and you can save records of all of these sort of hostile, unhelpful communications, voicemails, whatever, because they will come in handy down the road, especially if the landlord tries to evict you and you have evidence that the landlord was not trying to work with you at all and was just being unreasonable. So in terms of next steps, as you go through the negotiation process and we go through the renewed shutdowns that we're in, hopefully reopening is going to continue and resume once we get the outbreak in the area under control. The viability of defenses that we sort of talked about in the initial section where I talked about those key terms or paragraphs to look for. Those defenses to non-payment of rent, we don't really know sort of how they're going to hold up in landlord-tenant court, but it's good to know what's there and what you might be able to lean on in worst case scenario where you are up for eviction and the court can reduce the amount of rent that you have to pay for the periods that you were shut down and are not able to use your leased space. It sounds like we're making some solid progress in Congress for more stimulus, and that includes additional federal unemployment supplements, stimulus payments, and small business relief to the tune of, I think, $300 billion I saw last, and that includes another round of PPP loans. If you did receive a PPP loan earlier this year, there was a rule announced by the IRS, I think a couple of weeks ago, that said that you could not deduct any expenses paid with PPP loans or funds that were forgiven. And there's now legislation that would override that requirement. So you would be able to deduct those expenses paid with PPP funds and sort of double dip. So you could get a reduction in your tax burden on top of getting that forgiven, which would be additional help. And then additional small business loans and other funds should hopefully be on the way. Maybe right at the beginning of the year or sometime in January at the latest, hopefully. And I just watched a speech with President-elect Biden today, and he said that this is merely a down payment, so more relief will be on the way after he's sworn in toward the end of January. And as we get into February and March, depending on how things are going and the vaccination rates, we could see extensions of the governor's executive order and extensions of the protections, at least in San Francisco, which expires at the end of January, possibly Oakland and San Jose expiring at the end of March. So try to negotiate with your landlord beyond those dates if you can. That way it's not tied to the moratorium. But worst case, if they're extended, then it's going to give you more protection as well. There's been an issue that has been sort of litigated thus far in the pandemic outside of eviction, and that's been business interruption insurance. A lot of your leases require that you have that, and unfortunately, the cases that have gone through the court system so far, the courts have not found that the insurance policy in question covered a shutdown like has occurred during the pandemic. But if you have business interruption insurance, you want to look at the policy or at least provide it to your lease negotiation consult volunteer attorney, because if there are different types of qualified business interruptions defined in your policy that could include the pandemic, it could be an argument to raise that the business interruption insurance has to cover your losses. In the meantime, while we wait for the federal funding and potentially more state funding once we get into the next fiscal year in January, keep looking for new community financial resources. The City of Oakland and City of San Jose have resources for local businesses on their pages. And then in San Francisco, it's on the OEWD page under COVID-19 resources and businesses. Funding programs that were closed the last time you looked may have reopened. The one, I think SF Shine and then the SF Help are two examples in San Francisco that just recently reopened. And so you never know when new funding is going to come in. And it really, if you can set a reminder to check every day, if you can, every week at the minimum, just to see what things are out there, what you can apply for. Little things like $5,000 grants can help you get through, a month or two. And every little bit is going to help you. To sign up for additional possible resources, you can go to lccrsf.org to see what resources are available from the Lawyers Committee. If you're in Oakland, you can apply for one of the consultations, which again don't cost anything. It's a 1 hour opportunity to visit with a lawyer, get legal advice. Apply through this link for Oakland businesses and through this link for businesses that are not in Oakland. And again, the COVID-19 resources, Oakland City website, OEWD for San Francisco, San Jose, I guess it's SJE or SJEconomy.com, their city website. And we'll open it up for questions.
Jake, we do have a question. Says, can the landlord not renew your lease?
Sure. So I think the way that I understand the question is basically if your lease is up for renewal, can the landlord refuse to renew the lease? That's really going to depend on what the lease says. Some leases, it's the option is the tenants, and so if the lease says, you know, the tenant, you know, has the option to renew the lease 3 times at these intervals, and you know has to exercise the option by such and such date. Some leases say that both parties have to agree. Usually says mutual agreement of the parties, and that means that the landlord and the tenant both have to agree to renew. And so that would be a good reason to sign up for one of the consults so that we can have one of our volunteers look at the lease and see exactly what the requirements are. It could be that, yes, the landlord can refuse to renew, but if you can unilaterally exercise your option to renew, then the landlord would not be able to do that. So sign up for one of the consults if you're able to. It's not going to cost you anything, and you can get a solid answer.
It looks like that's all the questions.
All right. Well, if you have questions afterward, you think of, you know, you can reach out to the lawyers committee, sign up for a consult, and we can kind of talk those out. But in the meantime, happy holidays to everyone, and stay safe and take care.
Thank you, Jake, and thank you everyone for attending the recording of the webinar and also the presentation.
All right. Bye, everyone.